The Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by Brick criminal defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
Hi, welcome to So You Got Arrested. This is a podcast that discusses what happens from cuffs to courts as you go through the criminal justice system. I want to remind you that if you have questions or topics that you want discussed, you can email us at justarrestedpodcast@gmail.com. That's justarrestedpodcast@gmail.com. Now, Scott, I know you're a defense attorney, but in a former life, you used to do something else.
I was a prosecutor for basically 21 years. In and out, I was a prosecutor for 15 years, then went into private practice. Then when Nico LaHood became the DA, I came back to the DA's office. Then when he lost the election, I retired. And then I also was asked to come out and help out and prosecute out in Medina County with my good friend Mark Habe, who I went to law school with.
And I'll say, Scott, before you came to work with us, I was you and I had met a few times, but I was aware of your reputation because you've prosecuted some very high-profile cases, quite a few murders.
Yeah.
At one time you had given me the number of murders you had prosecuted. It was
I prosecuted hundreds, but I've probably tried like maybe 30 to 50 murders. I don't really keep track of them, but I've tried probably a couple hundred felonies. And then as a defense attorney, I've tried federal cases. Yeah, I've tried a lot of stuff.
That's what I wanted to discuss today. I want to discuss what the prosecutor is looking at when they get a case. Okay. Mm-hmm. And so let's take a scenario. Somebody is accused of a crime. Let's say it's possession of cocaine, right? So they get arrested, they post bail, they're out on bail, and the report. How does all that get to the DA's office?
So the initial magistrate report, like the offense report that the officer writes when they arrest you, that's in there off the bat. That's uploaded into the system. We can see it right away. What's supposed to happen, though, is that a follow-up detective on all felonies is supposed to gather up the rest of the evidence, which in a drug case is just going to be you're waiting for the lab report.
Right.
Okay. And so if you're in custody, you're entitled to be indicted within 90 days from the time that you were arrested, and we're not going to have that lab report back within 90 days. So you're probably going to get out on what we call a PR bond, which is just a small 3% bond that you don't have to go through a bondsman to make. But so on those drug cases, there's not a lot for the detective to do besides submit the drugs. They're the ones that submit the drugs off to the crime lab, and then they file the case with us, and then we get the results back at the DA's office.
And so because it's a felony, and we've kind of discussed this before, but for a felony to make its way into court as an officially filed case, it has to go to the grand jury.
Right. So in Bexar County, we have two different grand juries running at all times. There's a grand jury that meets Monday and Tuesday, and there's a grand jury that meets Wednesday and Thursday.
And what's a grand jury, if you could just describe?
So the grand jury is the same thing as a regular jury, but they're coming, instead of being called down for your jury duty to hear a trial, you're called down for grand jury. You don't necessarily know you're being called down for grand jury, so they call less people. So they may only call like 50 people and say 30 people show up. It's very different from picking a jury where attorneys talk to you. The 30 people who show up for grand jury duty, the judge sits there and says, who wants to volunteer? It's for 2 months. So for 2 months, you're committing to come into the grand jury room every Monday and Tuesday, but we usually have you out of there by noon.
Are you finding people guilty, or what are you doing in grand jury?
So if I'm presenting cases to the grand jury, I may come in, say I'm doing drug case, I may present 10 cases to the grand jury all at once. And then I leave the room when they vote, and 9 out of the 12 have to vote that there's probable cause to proceed with the case. In other words, there's enough that we think this case should be filed in court. And if you can't get 9 out of the 12 people to vote for a true bill, then the case is no bill and the case is dismissed.
And the case is over at that point.
Yeah.
Now, if the grand jury takes a look at your case and says, hey, there's not enough here to go forward, is it possible for a prosecutor like yourself to bring that case to the grand jury again?
It is. So sometimes a grand jury no-bills a case that shouldn't be no-billed. There's nothing preventing us from taking it to another grand jury. I'll give you an example. A long time ago, This is back when two famous prosecutors presented this murder case to the grand jury, where a guy had threatened a doctor's daughter, said, "You're not going to be able to watch her all the time, and we'll get her eventually." And so the doctor went out and shot him in the head.
Oh,
okay, and that's not self-defense,
right?
But the grand jury didn't like all the grand jurors said, "I'd probably do that too." So we presented to one grand jury. They no-billed it. There was a lot of outrage from the family of the deceased. And then they presented it to a second grand jury, and they also no-billed it. And at that point, we're like, we're not pursuing this case.
Right. Because that kind of gives you an indication as to, hey, this is what a regular jury.
If I can't get probable cause from 9 out of 12 people without a defense attorney arguing the other side, I'm never going to get 12 people to agree guilty beyond a reasonable doubt.
So when these cases come in to the prosecutor's office and the officers are turning in their reports, are there cases that you can look at and say, no, this doesn't pass the muster?
So I probably shouldn't say this out loud. So when I was a prosecutor before, most of the time I was a prosecutor, I was in family violence unit handling child victim cases, family violence cases. But I also was in regular criminal trial division. And a lot of those drug cases that were under 0.2 grams, I was rejecting those.
Okay. So this is where somebody gets caught and they might have just a minimal amount. I think that the way that I used to talk to clients about it is sometimes it might even be a situation where somebody may have used and tossed the empty bag down,
there's residue
in the car, and there's residue. They're residue cases.
Because remember, so a gram is a sweet and low packet. So now imagine 0.2 of a sweet and low packet.
Right.
Okay. So now that's one of those things I was just doing. If I told my supervisors, they'd probably say, stop doing that. Now, mind you, I'm not saying I was rejecting those if they had flushed a bunch down the toilet and all we had left was 0.2.
Right.
Or they shoved a bunch in their mouth. Don't do that because you can die. It's not worth dying over a drug case where you're going to get probation because you ate all your drugs. Because I had a friend when I was in high school who ate all the drugs and died of a heart attack.
Well, and that's if you don't die or nothing bad happens to you, you may pick up another felony. Right, the
tampering with evidence.
Tampering with evidence.
Some of those cases are bullshit, but that's a recent development that they're trying to get you now for tampering for eating the drugs.
Right.
I think a lot in the old days they used to say it's punishment enough that you ate the drugs and survived. But anyway, go ahead.
When you're looking at these cases and they're coming into you, let me ask you: does the criminal background of the accused play a role?
Yeah.
How so?
So now I don't look at the criminal background of the accused when I'm first looking at the case. Okay. But
why is that?
Because I don't want it to taint what I think about the case. If the case sucks, it doesn't become better just because you have a bad criminal history. Okay.
Now, it's fair to say maybe not all prosecutors do that.
That may be true. I eventually have to look at the criminal history because if I decide, oh, this is a good case, I'm going to indict it. Now I have to see if they're what we're called if you've been to prison before, you're now a repeater. So it elevates your crime one level. And if you've been to prison twice before, you're now habitual, which means your range of punishment is 25 to 99. So I got to look at that because I have to add that to the indictment. Okay. Because of like a DWI thirds, you have to look at the criminal history to make sure you have two judgments. Well,
let me ask you this, because, the reason I ask that question is I've had cases where, let's say somebody is charged with a misdemeanor family violence, and maybe the case itself isn't all that great. But I've had situations where prosecutors tell me, well, we looked at your guy's criminal history and he's had 3 prior family violence cases that were all dismissed, but that shows that there's something going on. What are your thoughts on that?
I feel a lot of times I feel the same way. If you've been beaten 3 different women, you've gotten away with it 3 different times, you may have to buy a trial on this 4th one.
So in that circumstance,
now if the case is not probable cause, we can't do that. But if it's a black eye and the woman is calling us constantly saying, I want these cases dismissed, I'm not going to dismiss that case.
Okay. And so that's a circumstance where criminal history, even though, from the outside looking in, you may have a defendant or his family saying, hey, wait a minute, all those cases were dismissed. Yeah. They may still come into play.
Right. And so it particularly happens in family violence cases. And it's so it makes a difference if you have prior family violence cases dismissed involving different people. Because then it's not just the problem's these 2 people, the problem's this guy. Okay. All right. And so, but remember, I'm still looking at it and the initial. So I have a 911 call that's saying he's beating me up, and I have a photograph of a black eye. And so the fact that somebody's now saying she doesn't want to pursue the case, I'm never going to dismiss the case because I have a good case that I can prove without her.
Right. And that's a question that comes up a lot. People want to know, well, look, if the person on the other side of the case, in a family violence case, maybe it's a spouse or, a significant other, but, sometimes maybe it's a theft case and they're saying, hey, look, the person on the other side of the case does not want this case to go forward. Does that mean that a prosecutor has to get rid of that case?
No, it doesn't. So what I like to say when people are calling us up saying they don't want to pursue charges, it's not going to be the prevailing factor in what we do with the case. It's going to be a factor.
Sure.
Okay. So in the end, I'm still going to look at the evidence. So if I have good evidence on the case and a reluctant victim, then I'm still going to probably go forward in the case. But then sometimes I have adamant victims and the case stinks, and I'm going to still dismiss the case because the flip side's true too. You have some victims who want us to pursue on something, and you realize this is somebody out with a vendetta. This case is no good. I'm going to reject it. And that's where sometimes weaker DA's offices don't have the intestinal fortitude to tell a victim complaining that, no, we're not going to go forward on this case.
Right.
Because they'd rather file it and lose in a trial than have the fallout of the person calling and complaining about them.
And that was my other question is if you have a victim on the other side, let's say it's an estranged family member who wants you buried under the prison, is the DA's office obligated to seek their approval for everything?
Okay, not their approval, but they're obligated to let them know what they're doing.
Sure. Okay,
so one of the things I always used to tell all my advocates and my younger prosecutors, don't call up, say you got a aggravated assault with a deadly weapon, okay? So if you call the victim up and say, what do you want to see happen on the case? They're going to say, we want the max. That's not how you do it. You call them up and say, I've been doing this for 10 years. This is what I'm going to offer on the case. I wanted to let you know. Okay. And then that's how you control that kind of thing.
Right.
And it's not to say that we don't care what the victim thinks, but I still, everything that we do as prosecutors should be based on what we think is going to happen in a jury trial.
Sure.
Okay. And I've tried enough of them that I kind of have a good sense. Now, that still doesn't mean that I couldn't try a case 3 different times in front of 3 different juries and get 3 different results.
Absolutely.
But I do have the experience that I kind of know how a jury is going to look at this. And I'm supposed to utilize that experience to decide what is a fair resolution for this case.
Well, and you hit on that, a fair resolution to this case, because a prosecutor's obligation in court is different from a defense attorney's obligation in court, right?
Completely different.
What is the prosecutor's obligation?
So prosecutor's obligation is written out in the Code of Criminal Procedure, Section 2.01. A prosecutor's duty is to see that justice is done.
And seeing that justice is done, does that include the defendant?
Yes. So justice for everybody.
Right.
Okay.
So it may be a case that you see that, you say, okay, I think this guy did do something, but I don't know if this is worth prison or I don't know if this is worth the max.
Right.
And then you handle it accordingly.
Which that's a great point. So if I have a family violence case and I have a wife who's calling up and saying, I want to dismiss the case, I get on the phone with them a lot of times and I say, I'm not going to dismiss the case, but what's happening is the defendant and the defendant's lawyer is telling her they're trying to send him in prison and then you're going to lose the house. And I say, I'm offering them 3 years deferred adjudication.
Which is a form of probation.
Form of probation where you don't show as a felony conviction. And I'm offering him. So the problem is when he's drinking, right? Well, I can make sure he takes alcohol treatment and I can make sure he does a batter's intervention. And then she says, well, he should take that. And then so I've worked out. I said, well, I already offered it to him and they refused it. And then next thing I know, I get a call from the defense attorney saying, we want to come in and take that plea offer that we rejected last month.
Right. And that's where clients may sometimes get frustrated saying, hey, I know, my wife has indicated this or my loved one's indicated this. Why isn't the case going away?
Right. And so it's important for everybody to know that just because your loved one is trying to get the charges dropped, it's evidence-based prosecution. We're going to make the decision based on what the evidence tells us, not based on what the person wants to do with it after the fact.
I appreciate that. And so that is our first segment here on So You Got Arrested, and we'll be back.
The attorneys at Brick Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search Brick Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. Brick Criminal Defense, helping our clients move on with their lives.
So, Scott, an issue that comes up quite a bit is there's times where, and keep in mind, I've only ever really done defense work. And so there are times where families will come to me and say, well, why won't the prosecutor offer this? Mm-hmm. Can a defense attorney make a prosecutor offer a specific plea bargain offer?
They never can make us do a specific plea offer. But I will say this. Most prosecutors will entertain a reasonable counteroffer. But here's the thing. I've had this happen multiple times. So say my offer is 5 years prison for this family violence assault, okay? Because he's had 2 or 3 priors and there's particularly good pictures of injuries, okay? If you come as defense attorney, come to me and say, would you offer me probation on this case? And I sit there and say, okay, well, let me go back and look at it. And then I go and I make sure that the victim is okay with it. And of course, she's been trying to drop the charges anyway. Mm-hmm. And so I look at the evidence again. I look at his history and then I call you, Steve, okay, I'll do 5 years probation instead of 5 years prison. And then you tell me, well, we're not going to take that either. Now I'm pissed off. Okay. Don't make a counter unless your client is going to take the counter. The idea behind a counter is you're telling me that if I do this, you'll take it.
Right. And I've had that situation before on the defense side where a client asked me, well, would they give me 5 years of probation? I said, well, let me work on that. And then I get back and say, hey, good news. They'll give you the 5 years probation. And the client says, okay, let me think about it. Yeah. And then you're stuck.
And so I'm very clear with our clients at Brick, the ones I handle. Like, if I'm going to make this counter, if they accept it, you're taking it. And you need to understand that.
Now, let me ask you this. When you're sitting in that role as a prosecutor and that defense attorney's coming to you and they're saying, Scott, you're offering 5 years in prison on this case. I'd like you to consider probation for my client. Are there things that the defendant can do to help in that cause?
Yeah. And so I may say to you, okay, first of all, are you saying he'll take the probation if I offer it? Because I don't want to agonize over it if he's not going to take it. And secondly, is there some things, what we call a mitigation packet? Is there some things you can show me that I can put in the file to help justify why I'm giving him probation in a case that maybe on its face doesn't deserve probation?
And what kind of things would those be?
Well, say he's got some mental health issues, but now he's getting help. Okay. Or say, and this is important. So the idea of the criminal justice system is we want you to not reoffend. Mm-hmm. So if you have a good job, a really good job, and pleading to this will make you lose your job, or rather than if you get deferred, you can keep your job, I'm going to seriously weigh that because my gal is still with him and they have kids together. Right. And things aren't going to get better for that relationship if he's now out of work and they get evicted from their house. Right. Okay. So as prosecutors, we got to worry about all that stuff.
Sure.
Okay. Because we care about the people. I try to tell all the DAs and the advocates, don't tell victims how to live their lives. So don't sit there and say, you need to leave this guy. That's not our business. Our business is the law was violated, the police were called, and there has to be justification. There has to be some consequences for their act. Mm-hmm. What that consequence can be, we can talk about till the cows come home.
Well, and a lot of times I'll explain to clients that the prosecutor has no idea who you are other than what's on that offense report and what's in your criminal history. Right. So to the extent that somebody can help me show who they are, whether it's through transcripts from a school, some letters from a job, maybe there's even times where I've submitted photos of the family, just to, hey, this is a loving husband, he's got a family, things like that, just to kind of show the prosecutor that, hey, this guy is more than just a criminal defendant on your report.
Right. And I've had a case where it turns out this guy who's has had a run of criminal history, his brother was murdered when he was 17 years old. Mm. I have no way of knowing that. Okay.
Right.
But then I can look it up once you tell me, but I have to look it up by the defendant's name, but I can sometimes look it up by the victim. But I wouldn't know that because it's not linked like that.
Right.
So then I see, oh shit, he was a good kid and he went off the rails when his brother was murdered. Maybe he found the body, whatever. Mm-hmm. And I'm like, okay, well, that changes my opinion of this. He needs help more than he needs prison.
Right.
Okay.
Now, going through that plea bargain process, again, I know there's times where people get frustrated and say, well, can't you make the state do this or that? There's times where we can help getting the state there, and there's times where we can't. But the defense attorney that you have, how important is that during that process?
It's important that you have a defense attorney who's everybody knows is credible.
What does that mean?
That you're not just come up and bullshitting me. Okay. Like there's for defense attorneys. I'll give you, I hope I didn't tell this story before.
Let's not name names, but
okay. I had a defense attorney when I was in family violence court, and it was, and there's a defense attorney came up to me and said, he never touched this woman. He went over there and they got into argument, but he never laid his hands on her. And this is a bullshit case. And I said, it's not an assault case. It's a violation of protective order. And he stopped for a second. And he said, well, he was never there. And we both started laughing. That's a problem. Okay. But it was funny at the time. But you have to be credible. And so if you're a defense attorney and you don't know for sure, I always say, my client tells me this and this about the victim.
Sure.
And then that way I don't look like I'm lying to the prosecutor if they look it up and say, that's completely not true.
And does the attorney's reputation make a difference during the case?
Huge.
How so?
Because I'm going to listen to you more when you come up to me, and I respect that you come and you're always reasonable in what you're doing. If you ask, if there's an attorney who's always asking, like there's some attorneys, defense attorneys out there who think every one of their clients is innocent and they want every case dismissed. Well, they don't have any credibility anymore. Mm-hmm. Okay. So I don't really care what their opinion is. I care what the file says.
Sure.
Okay. But the other part about that is we need to, as prosecutors, if we know you're a defense attorney who will never take a case to trial, you ain't going to get as good a deal.
Why is that?
Because we know that you're eventually going to take what we give you because you're not going to take the case to trial.
Okay. And so do prosecutors talk among themselves over, hey, maybe you're sitting in that prosecutor chair. I come up to you. I've never dealt with you, but I've dealt with other prosecutors in your office. Do they ever talk about?
Hell yeah, we talk about all the defense attorneys all the time, just like the defense attorneys talk about the prosecutors. Like this prosecutor's unreasonable.
Sure.
I hate being in this court. Or there's certain counties where we don't like to practice in. We won't mention any names because the prosecutors can be unreasonable.
Sure.
Yes.
Sure.
Both sides talk about each other, and both the defense bar and the prosecution have friends on each side. We go break bread together too at the same time.
Right. And so during this plea bargain negotiation that goes on, the defense attorney can make a difference in terms of the plea bargain.
Yes.
Let me ask you this. I get this question from time to time. Can I make the prosecutor dismiss a case?
No, you can never make a prosecutor dismiss a case.
Okay. Explain that.
Well, the only way I'm going to dismiss it is if I feel like it's justified to dismiss it. And so sometimes we get say, file a motion to have it dismissed. Well, the judge can't dismiss it. The only person who can dismiss it is the prosecution. And the only way the judge can dismiss it is if we go to trial and either the judge finds somebody not guilty or the jury finds somebody not guilty. So that's the way it has to go. So the defense attorney always has to approach the prosecutor hat in hand. We're used to, as defense attorneys, we're always asking because a lot of our clients, the case is very good for the state. He was pulled over because he had a bunch of warrants attached to that driver's license. And then he's got a kilo of cocaine in the front seat next to him. There's not a lot to work with on that case. So all we're doing is coming in and begging for a good deal from the prosecutor.
Sure. And, possibly with the threat of, hey, at trial, we're going to make this difficult. Yeah, even in cases where maybe, we may not win, but we're going to make it difficult if you take this thing to trial. We're going to kick up some dust and have some good objections and things like that.
But you got to be careful about the making it difficult versus kind of like a macho contest, like screw you, because if it's a challenge, I'm like, okay, all right, let's tee it up there, big boy.
Absolutely. Absolutely. So let me ask you this. With regard to these issues of going to trial, do prosecutors make decisions maybe based on the defense attorney's reputation about his abilities as a trial attorney?
That's a hard one. So we shouldn't, because it should be your concern about what might happen in trial. Mm-hmm. But when you are in your head, when you're voicing the concern about what may happen in trial, you can't ignore the fact that you know what the defense attorney is going to make hay out of this and this. Mm-hmm. So like every good prosecutor looks at a case and thinks, here's how the defense attorney is going to attack it. Every good defense attorney looks at the case and says, here's how the prosecutor is going to prove it. Mm-hmm. Okay, that's what good trial attorneys do on both sides of the aisle. Mm-hmm. Okay, and so what when you have somebody good on the other side, that because I've been surprised when I was a prosecutor when I'm like, oh, I have this and this weakness in the case, and we go to trial and none of those weaknesses are brought out.
Right.
Okay.
Right.
I'm like, oh, geez, they didn't. I would have brought that stuff up. But then when you have a good defense attorney on the other side, that stuff's going to be brought up.
Right.
That's the difference.
Right. Right. And so that what you've just talked about, that can impact the plea bargain negotiations.
Of course.
Okay.
Yeah.
Yeah. Let me ask you this. With regard to the prosecutor handling the case from the time that it's filed through a trial, does the defendant's conduct while the case is pending make a difference?
Yeah, it's the difference between getting a good. So so a couple things. If you're in custody and you're committing violations, disciplinaries at the jail, we're going to get that stuff. And that's going to be like, okay, well, what I was thinking before, now that's off the table. Also, there's jail calls where somebody's calling up their spouse and saying, you better get down there and get those charges dropped. Do
you guys get those?
Yeah.
You get copies of those?
Yeah.
So if somebody is on a jail call and they're talking to, because I've had this come up, where a family member says, hey, what happened? And they give an account of it.
Yes.
Now you're essentially making a confession.
It's all coming in. And it's not only is it a confession, but it's a confession that's completely admissible because it's not subject to 3822. 3822 being the section that controls confessions. But when police officers talk to you, they have to read your rights on the video. Not on jail calls.
But if you're talking to mama.
That's not part of 3822. In other words, that's just you spouting off. And all that stuff's coming in. And
I have, I've talked to people who get frustrated, who say, I'm talking to my loved one at the jail and they won't talk to me about the offense. And I tell them,
what's the first thing we tell them? Don't talk about the offense on the jail call. That's the first thing we tell a client.
Right. And it's natural because a family member wants to know, hey, what happened that night? Mm-hmm. How did it happen? And they get frustrated and say, well, they won't talk to me about it.
Yeah, they should not be.
What about letters?
Those letters are reviewed before they go out and before they come in. Okay. The only time they're not is if if you sent me an attorney when your attorney a letter and say legal mail, they're not supposed to open that.
Sure.
However, there's been some people in prison who've used that and had their friends send them fake legal mail that had drugs in it.
Sure.
So now they kind of open it anyway.
Okay.
They just make sure it really is legal mail. I've gotten calls from the prison saying, did you send so-and-so a letter?
Did you send so-and-so cocaine and fentanyl? So let me ask, as a defense attorney, I can honestly say that nothing worries me more than when I'm getting prepared for the trial and then the state hands me a hard drive and it's 100 jail calls. Yeah. Because now I'm worried, oh Lord, what did my client say?
So we don't always pull all the jail calls because there might be a lot, but we usually pull them like right after you're arrested, and we usually pull what happens right before trial, because right before trial, everybody starts talking to their family and friends about the case. So then, yes, we pull those jail calls and we find out, oh, geez, he's talking about this. And then we make copies, we present them to the defense and say, hey, that case you thought you were going to kick our ass on, maybe not so much anymore.
Now, is there anything that you would say that somebody charged with a crime could do that would make a difference to a prosecutor? Like when you were a prosecutor, something that you would see and say, hey, I'm on the fence about this, but this guy did this or that. And that.
Really think outside the box on those kind of issues. It's anything you can do well to show you're a productive member of society. So I'm taking classes. I haven't gotten in any more trouble. I haven't had any positive UA. I haven't peed dirty while I've been on pretrial. And I've turned my life around since this. Now, we all are a little bit suspect. It's like atheist in a foxhole kind of
Sure,
thing. Like,
right.
you know, there's charges pending, so you're on your best behavior. But when you continue, but there's a lot of people who aren't on their best behavior when they have charges pending.
Right.
So when we're trying on those cases where we're on the fence about what to do, and then the person has made some positive gains in their life, and you can show that to me as a defense attorney, we're gonna take that in consideration. It's going to help you.
Yeah, absolutely. And so we hope that this advice helps those of you navigating your way through the criminal justice system. Thank you for listening. This is So You Got Arrested, sponsored by Brick Criminal Defense.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, Brick Criminal Defense has your back. For more information, visit us at brckdefense.com.